Hello, everyone, and welcome to the recording of Context is Everything, Battered Women Charged with Crimes. My name is Charlie Whitman. I'm an Associate Attorney Advisor at AEquitas, the Prosecutor's Resource on Violence Against Women, and I will be moderating today's presentation. This presentation will discuss how to use a contextual analysis to evaluate cases where victims of intimate partner violence are accused of criminal offenses. Today's presenter will talk about applying a predominant aggressor analysis and also about holding victim defendants appropriately accountable for criminal offenses. Today's recording is hosted by AEquitas, the Prosecutor's Resource on Violence Against Women, through funding from the U.S. Department of Justice Office on Violence Against Women. Written materials, including a copy of the PowerPoint presentation and the presenter's biography, are available upon request following your viewing. AEquitas' mission is to improve the quality of justice in sexual violence, intimate partner violence, stalking, and human trafficking cases by developing, evaluating, and refining prosecution practices that increase victim safety and offender accountability. AEquitas provides prosecutors with support, training, mentorship, and resources necessary to objectively evaluate and constantly re-examine and refine their approach to justice. AEquitas staff conduct legal research, provide 24/7 case consultation, host specialized or state-specific training events and webinars, provide individual experts to jurisdictions and organizations, and publish articles, monographs, and other resources on topics relevant to the prosecution of violence against women. Today's presenter is Teresa Garvey, Attorney Advisor at AEquitas. Prior to joining AEquitas, Terry worked for 22 years as an assistant prosecutor in Camden County, New Jersey. For 9 years, she was assigned to the Domestic Violence Unit, and for 5 of those years served as Deputy Section Chief of that unit. Ms. Garvey worked closely with the Victim Witness Advocacy Unit to provide education to the public and to communicate leaders and to community leaders who come into contact with domestic violence victims. Her jury trial experience included the prosecution of domestic violence crimes, sexual assault and other violent crimes, drug offenses, property crime, hate crimes, and official misconduct. Ms. Garvey also has extensive appellate experience and has briefed and argued numerous cases in the appellate courts of New Jersey. Terry's full biography and a PDF of today's presentation are available upon request following your viewing. At the conclusion of today's presentation, participants will be better able to use contextual analysis to evaluate cases where victims of intimate partner violence are accused of criminal offenses, and we are able to apply a predominant aggressor analysis and to hold victim defendants appropriately accountable for criminal offenses. Just one thing to think about throughout today's presentation, just one caveat is the contextual analysis used in the cases discussed is applicable to all victims of abuse, regardless of gender. I'd now like to turn the floor over to Terry for the substantive portion of today's presentation.
Thank you, Charlie. Welcome, everyone. We're going to be talking a lot about context today. And to start off, we're going to consider an example of the importance of context taken from one of the greatest legal dramas in the history of film, My Cousin Vinny. Anybody who's seen that show, if you have, you'll recall that the movie opens with 2 college students, Billy and Stan, who are making a cross-country trip through the Deep South. They stop at a convenience store to pick up some groceries. Billy has his hands full, so he slips a can of tuna into his pocket. Once they're on the road again, they get pulled over by a police car. Billy remembers that he's got this can of tuna in his pocket that he forgot to pay for. The young men are arrested at gunpoint and taken to the police station for questioning. Billy assumes he's being charged with shoplifting. Unbeknownst to him, however, the convenience store was robbed just after they left, and a clerk was killed during the robbery. So in the next scene, the sheriff is interrogating Billy about what happened in the store, and he listens to Billy's tedious recitation of their grocery shopping trip. And the sheriff finally demands to know, at what point did you shoot the clerk? Billy repeats in stunned disbelief, I shot the clerk? I shot the clerk. And of course, at trial, the sheriff testifies that he questioned the suspect, who stated, I shot the clerk. So just as words taken out of context can be misleading, the same is true of actions. If we evaluate our cases looking only at the elements of the criminal offenses, and if the acts of the party are unmoored from their context, we are not in a position to do justice. And if we're mechanically applying the letter of the law, but ignoring the circumstances that preceded and surrounded the actions of the party, we are not applying the spirit of the law. So one of the terms which Charlie used when she was talking about our learning objectives, for the purposes of this webinar, we're going to use the term victim-defendant. And what we mean by that is someone who is a victim of prior battering, who has been accused of a crime under one of the following circumstances: either an act of violence committed against the abuser, other offenses or criminal acts, or what appear to be criminal acts where abuse may be a factor in what occurred, or situations where the victim of abuse has been falsely accused of a crime by the abuser. Now, clearly, under our criminal statutes, not all acts of violence are created equal. Even outside the context of domestic violence, we recognize a number of defenses that apply where someone's use of violence is justified, including self-defense, defense of others who would have a right of self-defense, coercion or duress defenses, which probably don't go up to extremely serious acts of violence, but covers a lot of what otherwise would be crimes when someone is acting under coercion or duress from another person, or necessity defenses where the action is absolutely necessary under the circumstances. But even apart from the criminal defenses, we still consider our criminal statutes are crafted to consider the context in which a certain act occurred or was committed in various places. First of all, when we're deciding whether a diversionary disposition is appropriate, usually the context of the act is important in that decision. When we are deciding what an appropriate plea offer is, generally speaking, most criminal offenses have a range of sentences available, and there are usually a variety of aggravating and mitigating factors that can be considered, and often those aggravating and mitigating factors will arise from the context of the actual incident. We also have, even apart from the plea offer, if someone is convicted after trial, the court will consider mitigating factors in sentencing or aggravating factors. And again, many of those factors may arise from prior circumstances like criminal history, or they may arise from the context of the actual event that is subject of the criminal conviction. Also, in determining what appropriate sentencing conditions should be imposed, if someone is getting, for instance, a probationary sentence when the court is deciding what appropriate probation conditions would be, often they will look at the context of the act and consider whether that has any impact on what would be appropriate sentencing conditions. So we've got a couple of hypotheticals we're going to do here. And Charlie, if you would read this hypothetical, please.
Yes. So Sarah is arrested for striking her boyfriend David in the face with a coffee mug, causing a laceration that requires stitches. An independent, credible eyewitness states that there was an argument and that David shouted, "Now you did it," but never struck Sarah or motioned as if he was about to strike Sarah before Sarah injured him. Sarah is arrested after fleeing the scene.
Oops. Now, the question I'm going to ask you to consider after hearing that hypothetical is whether the facts that have been provided give you all the information you feel that you need to decide whether to charge Sarah with a crime. And further, is it relevant at all whether or not Sarah was previously abused by her boyfriend? When we talk about contextual analysis and how to properly evaluate the context in which an act of violence arose. What we're trying to do is to determine what the intent was of the violence. And we have four types of violence here, four categories that we run into quite often in our criminal practice, and each has a different intent that is being advanced by the act of violence. In the battering context, which we see, of course, every day in our domestic violence practice, the intent of the violence generally is to control the victim or to control the relationship. Somehow the batterer has lost control of the victim or the relationship, and the intention of the violence is to bring that victim or the relationship back within his sphere of control. We also have pathological violence, where the intent of the violence is impacted by pathology. People who suffer from grave mental illnesses or are under the influence of intoxicants or have other kinds of mental health problems may act out in a violent way in response to those mental health issues. So that's another category that we see in our practice. Next, we have situational violence, where the intent is to control a situation. This is not something generally that is habitual. It's not like a relationship where the same incidents are happening every day. It's not something that comes out of the blue like pathological violence, but it's something that arises in a particular way, and the person acts out or reacts in a violent way in order to control that situation, because that's the option that they see available at that time. We also have reactive or responsive violence, where someone who is a victim of battering is either in some fashion addressing or responding to the battering. So we're first going to talk about how to evaluate and identify acts of violence and start to put them into these categories by using contextual analysis. And the threshold question really is whether prosecutors can ethically treat intimate partner victims who use violence differently than we do batterers who use violence. And McCluskey versus Kemp, which is where this quote comes from, was a U.S. Supreme Court decision in which someone who had received a death penalty sentence was challenging imposition of that sentence because the statute under which the sentence was imposed gave the prosecutor the discretion to seek a capital sentence by charging certain aggravating factors, predicate factors that would allow the death penalty to be imposed. And the defendant was arguing that giving the prosecutor that discretion violated his right to equal protection. It was, and due process, that it was giving the prosecutor too much power. However, the court disagreed with that and stated that the capacity of prosecutorial discretion to provide individualized justice is firmly entrenched in American law. As we have noted, a prosecutor can decline to charge or offer a plea bargain. The power to be lenient is also the power to discriminate. So the court clearly has recognized that that individualized justice is the goal, that we are not supposed to be treating all defendants the same, and that in some situations leniency is appropriate, and in some situations a harsher approach is appropriate. And this principle is also recognized by the American Bar Association in its standards for criminal justice. We first have discretion in deciding whether to charge someone with a crime as opposed to diverting or dismissing or handling the case in some other fashion. The prosecutor can, in some circumstances, and for good cause consistent with the public interest, decline to prosecute. We also aren't obligated to go for the most serious offense that the evidence would support. we can settle for, we can charge, we can dispose of a case using a much lower degree of offense where that is appropriate, even though the evidence might support a more serious charge. We also have discretion in deciding whether a case is appropriate for diversionary treatment. The prosecutor should consider in appropriate cases the availability of non-criminal disposition, especially in the case of a first offender. Prosecutors should also be familiar with resources of social service agencies, which can assist the evaluation of cases for diversion from the criminal process. And that is, again, from the ABA standards for criminal justice on the prosecution function. So prosecutors not only have the discretion, we also have the responsibility to use that discretion to adjust our response when doing so is A, in the interest of justice, and B, based upon specific identifiable criteria. We have to remember not only are we going to have to answer to our supervisors, our bosses, about how we handle these cases, and we better have a good explanation for treating some offenders differently from others, but we are also going to have to answer to the citizens who we are sworn to protect. And we have to be able to explain to them and justify to them our reasons for providing this individualized justice, which in some cases may provide for a much lower sentence than the public expects we will. So we're going to first consider the use of violence by victims of abuse. We're going to be talking a little bit later about other kinds of crimes, but right now we're going to focus on victims who are charged with crimes arising from an act of violence that they have committed. And first we're going to consider the use of violence against the abuser. Part of the problem in approaching these cases is that our criminal domestic violence statutes tend not to be real helpful in terms of categorizing them. We're dealing generally in the statutory setting with broad categorical definitions. We're looking at the elements of the crime. What specific act occurred? What was the injury that was inflicted? What was the mental state at the time? And that's generally what we're looking at when we're deciding whether a crime has been committed. Also, if you happen to be in a jurisdiction where you have specific domestic violence crimes, you're also going to be looking at the victim-defendant relationship, whether it fits within the category that is defined in the statute in order for a crime to be prosecutable under that statute. It might be a family member, might be a spouse or a dating partner, might be family members or household members. So you're going to be looking at the elements of the crime, which may include this relationship. There's not a lot of nuance in the statutes themselves, generally speaking, to categorize crimes according to what made them happen. That's generally left to the sentencing statutes. Contextual analysis considers, first of all, domestic violence dynamics. These are complex dynamics. We're thinking about issues of power and control. Many of you are familiar with the power and control wheel. Domestic violence is generally about the abuser trying to exercise control over the victim. We're talking about actions and reaction. One person acts, and maybe the victim or the abuser, the other party reacts to that, and it may escalate from there. Both parties are generally anticipating what the other party is going to do, what is going to be the response. And so that factors into it as well. These are also dynamic offenses or acts, which means that often they fall on a scale of severity, a scale of blameworthiness. Acts may not be all bad or all good. They may fall somewhere on this continuum. We also will be talking about the fact that DV dynamics are influenced by history, the history between the parties, their past experience with each other, and perhaps their past experience even with other partners. But what they expect to happen, how they interpret the other party's actions. Our focus when we are looking at or undertaking a contextual analysis is on what is the intent of the violence. We need to try to differentiate among many acts of violence, and part of how we do that is deciding which of those categories that we talked about before it is that we're dealing with, whether we are dealing with a batterer or with someone who is reacting to violence, or maybe one of the other categories. But it will help us to determine what our most appropriate response is, not only in the context of charging and prosecuting these cases, but also in terms of the services that we may need to be offering from the advocate standpoint. So this is just the same slide that we saw before. It's just to refresh your memory about the categories we're talking about: battering, pathological violence, situational violence, and reactive or responsive violence. And we have another hypothetical here. Charlie?
Yes, so this hypothetical is about James. James is a 32-year-old male arrested for simple assault. He grabbed his wife Sandy by the shoulders during an argument, leaving bruises, and pushed her down on the couch. Police were called by a neighbor who heard a loud argument and a scream. The neighbor saw James jump in his car and leave the scene before the police arrived.
So just based on that information, does it look like James is a batterer? Doesn't that scenario sound pretty familiar? Isn't that kind of a typical battering kind of situation? But there are some additional facts in this case that the police officer who responded learns after he gets there.
2 months earlier, the couple's 8-year-old daughter collapsed on the playground and died on the way to the hospital. There's no history of violence. Sandy's been urging conversation and counseling to address their grief issues. James refuses to discuss their grief, saying there's nothing we can do about it. On the date of the incident, the couple were arguing. Sandy told James that he needed to confront the grief and counseling or their marriage would fall apart. Overwrought with stress and grief, James grabbed Sandy and pushed her down, then left to avoid further arguments.
So having heard those additional facts that the officer learned, do these facts change your thinking at all about what kind of a situation we're dealing with? Does this appear to be a battering situation where the defendant is intent on controlling the victim? Doesn't sound like it. There's no history of that, and she's not trying to make him do anything, or she's not asserting independence that he needs to stop. Pathological violence, there's nothing really to indicate that. And certainly there's no indication that he is responding to battering inflicted against him. So really, this seems to be a case of situational violence, where the defendant, in this case, James, is the defendant. He's not a defendant victim because he's not responding to the battering, but his intention in grabbing Sandy and pushing her down on the sofa is really to deal with his own anger and to get away before the situation escalates. So different categories of intent and context as you're gathering require different prosecution responses. We're going to talk about the law enforcement and prosecution response, and we have several challenges in doing this contextual analysis. Among those are mandatory or pro-arrest policies, self-defense analysis, predominant aggressor analysis, which we'll define and talk more about, and conduct that is just plain illegal, that's not justified in any by any legal definition. Mandatory and pro-arrest policies are law or policy in many jurisdictions, and really they were created as an improvement to what existed before. Years ago, as most of us know, the police used to come out in response to a call, a domestic violence call or a domestic disturbance call. Quite often it was referred to in those days. And they would find the parties, maybe one party's injured, maybe both parties are injured. And the officer's response quite often would be to ask the person who was responsible for the violence, the batterer, to go out and take a walk, settle down, everything's going to be okay, go sleep it off, go stay at your buddy's house, and people were not getting arrested for domestic violence. It was not considered to be a proper subject for criminal prosecution. It was considered to be a private matter. And because that was where we were starting and what we were trying to overcome, many jurisdictions started instituting mandatory or pro-arrest policies, which required or at least exercised or indicated rather a strong preference for arrest of someone where an act of domestic violence had been committed. Now, the standard for that was very low. It was probable cause. If the police got there and there was enough to satisfy the probable cause standard, which is, as we all know, a very easy threshold to meet, then an arrest was mandatory. The unintended result of this was that there was a disproportionately higher rate of dual arrests where both parties would be arrested, because how often do the police go out and both parties are exhibiting signs of injury and each party is being accused by the other of being the aggressor? So both parties would be arrested. They might be charged with mutual fighting or some other similar statutory definition, and a lot of victims were being arrested when really, if they did anything at all, they might have been acting in self-defense. So it was a good idea, and it, in many places, there still is a preference that is effective, but we don't want to be mindlessly imposing these mandatory rules that are going to wind up catching victims within the net. Defense of violence, self-defense, is something that needs to be evaluated by the police and by the prosecutors. And self-defense, if you read, most criminal codes have a statutory definition, and self-defense generally requires both necessity and imminence. We have to look at whether there was a threat of harm and what kind of harm was it. Was that threat of harm imminent? Was it about to happen, or was it something that just might happen at some point in the future? Is there a necessity for the use of force, or can the threat be dealt with in some way short of using force? And finally, if force is necessary, is it a reasonable degree of force, or is it the response of force way out of proportion to the threat that the person is responding to? In the domestic violence context, it becomes more complicated, however, because first of all, the nature of the threat is such that what is considered by a victim of battering to be threatening is interpreted through past experience. And conduct that is objectively benign may not look like a big deal at all to anyone on the outside, may constitute a contextually imminent threat. In other words, the victim may have information that we as outsiders do not have, and they are reacting in response to that information that they have about what's gone on in the past, what they can predict will happen, and what certain conduct on the part of the abuser means. So we have We're going to go back now to the Sarah hypothetical, which was the very first one. That was the victim or the person who struck her boyfriend in the face with a mug, causing stitches. And there are some additional facts that we're going to consider with regard to that scenario. Charlie?
Yes, Sarah's been battered by her boyfriend in the past. She's often beaten after David uses certain phrases such as, "now you did it." The last time David announced, "now you did it," Sarah was severely beaten and taken to the emergency room.
Now remember that from our original scenario, David shouted, "now you did it," before Sarah threw the coffee mug, striking and injuring him. Now, given these additional facts that we've learned, what do you think was going through Sarah's mind when she heard that? Obviously, she's going to be interpreting those words in light of her past experience. And the law of self-defense provides that individuals have a right to defend themselves to prevent harm, and it doesn't prescribe that defense may only be used if the person is actually harmed. In other words, you can act in self-defense before the threat ripens into the actual harm. So when police are responding to a domestic violence situation, and when prosecutors are evaluating cases after the reports have been written and witnesses have been interviewed, we need to know how we can recognize when someone is acting in self-defense or may be acting in self-defense. And we have to consider the fact that there are often subtle precursors to violence in an intimate relationship. These include such things as a certain tone of voice that a victim will recognize as the batterer about to use an act of violence against her. There may be certain gestures that are used, a fist held up, for instance, or a slashing motion across the throat that the victim is going to recognize is signaling that an act of violence is about to occur. Victims are often incredibly good at assessing the batterer's mood changes, very subtle shifts in mood that may not be that obvious to someone who is not in that relationship and hasn't been beaten by someone and hasn't had to carefully interpret these subtle changes in mood. Victims are often hyper alert when they are in a battering relationship. They're often hyper vigilant. They will recognize and are constantly assessing what the mood and actions and demeanor is of the batterer so that they can be prepared to deal with whatever is happening. Facial expressions. If you read or talk to victims of domestic violence on an ongoing basis, you'll hear over and over again, "He gave me that look, and I knew I was about to get it." Often they are very adept at reading these subtle expressions. And in addition, we can also consider context based on any prior history of violence by either party. Predominant aggressor analysis we referred to previously, and it is now mandatory for police in many jurisdictions. Often there is something in either the law or else in departmental policies that require officers responding to domestic violence cases to undertake this kind of analysis. In some jurisdictions, they'll call it something else. In some jurisdictions, they will call it a primary aggressor analysis, or I'm blanking on the other expression. But in any event, it may be referred to in a different term, but it's often mandatory. And the goal of this is really to address that issue that we talked about before of dual arrests or arrests of victims. It helps us, when we undertake this predominant aggressor analysis, it helps us to differentiate between the abuser and the victim so that we are protecting or prosecuting the right person. We don't want to be arresting victims. We don't want abusers to be escaping accountability. And from a practical standpoint as well, dual prosecution is simply impractical. If you have two parties who are both going to be prosecuted for acts of violence against each other, you're going to run into a host of problems, not least of which is that both parties are going to have Fifth Amendment privileges. So it is, from a practical standpoint, it's just impossible. So what we want to do is reduce. Now, there may be some circumstances where there is truly a mutual fight between the parties, and they're equally matched, and neither is the primary or predominant aggressor. But in other situations, the vast majority of situations, a proper predominant aggressor analysis will help you to uncover who the primary aggressor is or predominant aggressor is. And what are the kinds of things that we're going to consider as part of this analysis? For one thing, the history of violence between the parties. And we can get that from looking at 911 calls to the residents. We can look at the actual NCIC criminal histories between the parties. And we can consider the type and degree of physical injury that both parties are exhibiting. We can consider what kinds of injuries either party has, whether one is displaying defensive type wounds that were inflicted while they were trying to defend themselves. We can consider whether the response appears to be proportionate. Now, in some circumstances, if we're undergoing or undertaking a proper contextual analysis, in some cases the response may seem disproportionate, but based on the history between the parties, the threat that's actually there that the victim is anticipating is sufficient that perhaps a stronger response with a weapon, for example, may be appropriate because she knows that the beating she's about to receive is such that that's the only way that she can safely defend herself. We can examine threats and acts that create a fear of injury. What did the defendant say or the abuser say before the victim responded? What kinds of acts did they engage in? Perhaps picking up a weapon, perhaps making a motion as if to do so. That may increase the fear of injury on the part of the victim. We can consider statements from the parties, both parties interviewed separately, and any other witnesses to the incident, especially children, if they happen to be present. They will quite often be able to tell you accurately exactly what happened, and they are also good sources of information with regard to any history of violence between the parties. And, of course, part of predominant aggressor investigation includes self-defense analysis, but they are actually two separate things. The on-the-scene investigation to determine who the predominant aggressor is requires proper training, and it's important for officers responding to the scene to keep in mind that abusers are generally expert manipulators. They're extremely good at appearing to be calm, reasonable. They will have an explanation for what happened. They'll be the ones who appear to be completely in control of the situation because, in fact, they are. On the other hand, victims of battering, when the police go out to the scene, may be extremely emotional, fearful, crying, hysterical, or they may be intoxicated because, as we'll see, responding to domestic violence victims often do turn to alcohol or drugs as a coping mechanism. It's also important, as we stated a moment ago, for the officers to talk to any children at the scene. So the training and awareness and alertness needs to be instilled in the officers when they respond, and officers also need to be documenting these details in their report. Even if they wind up making an arrest of both parties, or maybe it turns out that they've arrested a victim of battering, these have to be reviewed later, and the prosecutor needs to be able to look at this so they know which leads to follow up in order to complete the predominant aggressor analysis, which may be relevant to the overall disposition of the case. Now, there are some limitations to predominant aggressor analysis. First of all, because it's talking about physical aggression, it's really limited to investigations of abuse that involve physical aggression and not other kinds of offenses. Also, because it's looking at actions and reactions, it may not always account for more subtle precursors to violence, which is why it's important to ask those questions about what made the victim of battering perhaps believe that she was about to be subjected to a violent act. It also requires, and this is one of the most important limitations, it requires the availability of historical information, and quite often that information is controlled by the accused victim. Now, police officers are going out, and if before they're questioning, because they believe that a victim defendant is in fact a real defendant or someone who has not lawfully used violence, they may read that person their Miranda warnings, and the victim may exercise her right to remain silent. By the same token, even apart from that, victims may be reluctant to divulge all this historical information. They probably won't volunteer it. It probably needs to be specifically requested. And some of that information may not be available until a later time, which doesn't mean that we forget about it. We can still try to get it later, perhaps through a defense attorney or someone else, family members, friends. But at the scene, when the officers are doing their initial investigation, often there is a real lack of historical context for those officers to rely on. So some of the biggest barriers to contextual analysis is, unfortunately, us, law enforcement, defense attorneys who maybe don't bring the issues or the history of battering to the attention of the prosecutors, the courts themselves, advocates, prosecutors, and this happens in a variety of ways. One is that these individuals or entities fail to conduct a proper predominant aggressor analysis. They may conduct poor victim interviews and evidence collection, and the self-defense or claims of self-defense is not analyzed in a historical context. So those are some of the biggest mistakes that can be made that lose this information that helps us put this particular act of violence into its proper context. Other kinds of illegal violence or illegal violence. Charlie, if you could return to the Sarah hypothetical once more.
Yes, so Sarah was arrested for the identical offense, but her boyfriend never uttered the words, "Now you did it." Rather, Sarah tells police that she has been abused by the defendant in the past and was fed up and angry and wanted to hit him to show him how it felt. She affirmed that she was in no way defending herself from her boyfriend.
So, as in that situation, some victim-defendant conduct is not justifiable. And it may take the form of retaliation, making the abuser pay. As Sarah said, I wanted to make him see how it feels. or striking out simply in frustration and anger. This person has been subjected to violence for a very long time. They've had it, and they just don't know how else to react at that point except to strike out in kind. But nevertheless, it's important to note that even in those scenarios, even in those settings where there is elements or are elements of retaliation and striking out, the intent of the conduct may nevertheless be to prevent or preempt future abuse. Sarah is probably hoping, on some level at least, by hitting hitting her boyfriend with the mug, that he will stop, that he will realize that this hurts and stop acting that way. It may not be effective, but that may still be the intent. So one of the places we want to start is examining the criminal history of both parties. We want to run rap sheets, criminal histories on both parties, and that can provide us with actually quite a bit of information. We can take a look at any calls for service, how many times the police have been out to the house. We can take a look at who has been arrested and for what. We can take a look at who has been convicted and for what. We can take a look at which kinds of incidents probably have police incident reports, and we can obtain those reports from the other jurisdictions if they appear to have some relevance to the claim that or possibility that the defendant has actually been a victim of battering. And we may be able to look at orders of protection as well. Who obtained an order of protection against whom? And this will help us to distinguish. Examining these histories can help us to distinguish someone who has a history of aggressive, abusive, and violent behavior from someone who may be reacting to a current abusive relationship. And the fact that the other party or that a victim defendant has been arrested more than once doesn't mean that those prior incidents were not responsive or reactive violence as well. So when we're examining criminal histories, we want to consider, first of all, when we're talking about prior criminal charges or responses where there was an act of violence against the same party as the one who we're dealing with in the present case. That indicates violence within the context of that particular relationship. And as I said a moment ago, the fact that there are multiple incidents don't necessarily mean that the violence is non-reactive. We also want to look at whether there is violence in prior relationships or directed at others. And that's indicative of a more general violent tendency. When we have someone who has multiple restraining orders against him by multiple victims or multiple acts of assault filed against him or that involved multiple victims, intimate partner victims, then we know we are probably dealing with a batterer. On the other hand, if we have someone who maybe has multiple acts of violence for which he's been arrested or convicted, but they are not, for the most part, intimate partner incidents, that may just indicate an overall violent tendency arising perhaps from a pathological kind of violence. And among the places where we can get this history that we use in our contextual analysis, we can look at the history of violent behavior, looking at previous documentation, documentation that already exists, maybe in other jurisdictions, and that will require us to request those police reports from those other jurisdictions. There may be new documentation. It may be revealed for the first time. There may not be prior arrests but in an interview with a victim defendant, it may be disclosed for the first time that there has been this long history of violence. And then we have to find out whether, in order to corroborate that, or in the hopes of corroborating that, we can find out whether the victim defendant has ever disclosed this to anyone else, maybe a family or a friend, or whether there's any other corroboration, such as medical records from prior treatment after injury. We can also interview both parties and conduct interviews with family member and friends who can probably tell us what the history is with these parties. We also, when we do find that there is a history of abuse by the complainant or the complaining party in this particular incident against this victim defendant, that's a signal that we need to anticipate and address ongoing safety issues for the victim defendant. That person doesn't stop being at risk simply because they've been charged with a criminal offense. They may need shelter. They may need advocacy assistance. We also have to be alert for system manipulation by the complaining party. Someone who has managed to get, a batterer who has managed to get his domestic violence victim arrested by police and into the criminal justice system has an even greater level of power over her now than he had before. So we have to be very careful that we do not become manipulated by the complaining party and don't become another weapon in his arsenal. We also have to be careful that we're alert for manipulation by the complaining party against the victim defendant throughout the course of the case. She may be under bail conditions, and the complaining party may threaten to violate those or report violations of those conditions on a regular basis, may threaten to disclose additional harmful information. So, again, this criminal charge can be a terrific weapon in the hands of the abuser against the victim, and we have to be careful that that does not happen. So it can also be important sometimes to put some of this context into its own context, because some of the information that's uncovered during the course of our contextual analysis may have to be put into a context of its own. And Charlie?
Yes, so criminal records reflect that Sarah has a chronic drug habit with numerous arrests and convictions for possession of cocaine. The history started 6 years ago with marijuana possession and has graduated to the recent arrest for cocaine possession.
So, generally speaking, when we think about witnesses or defendants in cases, how do we normally look at someone who has a lot of drug arrests? Do we normally look at them as if they are very credible? Or do we start perhaps discounting the truthfulness and the accuracy of what they tell us because of those criminal convictions, because of that drug abuse history or alcohol abuse history? So there's some further questioning that's done by the police, and they find out, Charlie?
The police find out that Sarah discloses the abuse she suffered over the years was so severe that she turned to alcohol and drugs as a coping mechanism. Her criminal history in this context may bolster rather than discredit her history of abuse.
So that's what we mean by putting the context in context. The disclosure of the drug and alcohol abuse can actually be considered to be a not unusual response to battering. We also need to continue our contextual analysis when we are deciding whether diversionary treatment is appropriate. versus a criminal conviction or a criminal prosecution leading to conviction, and also what kind of sentence is appropriate. And our question now becomes, should the legal consequences for victim defendants who use illegal violence be different from battered defendants? And our goal is to hold victim defendants appropriately accountable by whatever decision we make. We want to reduce or eliminate the violence. We want to provide a victim defendant with alternatives to violence. We want to minimize harmful collateral consequences of criminal convictions. And we want to reduce the incidence of abuser manipulation of the criminal justice system and of the victim defendant. So these are our goals when we're analyzing how we should dispose of a case. Criminal convictions are certainly one option, but they certainly have a downside when we're talking about victim defendants. For one thing, it is going to create a barrier for future access to the criminal justice system because this person has now been labeled as an offender or abuser. If they are a victim in a future case, they are going to have these criminal convictions that can be used as an attack on their credibility as witnesses. It can also eliminate their ability to receive advocacy services because certain kinds of victim services are not available to, for instance, prison inmates. So someone who is a defendant may not have the availability of those services that would benefit them. In addition, when someone has a criminal conviction, that follows them when they are seeking employment. So not only is this person now settled with a criminal conviction, but they are not going to be able to get a job, which increases their economic dependence on the batterer. There are also other unfortunate collateral consequences of criminal convictions. It can impact civil proceedings in the divorce or child custody context. Having a criminal conviction generally does not look good if you're trying to regain or retain custody of your children. It increases safety concerns because if someone has been arrested once after calling the police, they're probably not going to feel very secure about picking up the phone and calling 911 on a future occasion. If she's still with the batterer has a lot of power over her, even with a probationary sentence, because that probation can be violated. And that can be used, again, as a very powerful weapon to control and manipulate the victim by threatening to report them to their probation officer. It also increases the likelihood of false reports by the batterer complainant because the batterer has seen that this worked once, and therefore that's positive reinforcement. And let's face it, the batterer feels that and may be right that the police are going to believe him, going to be more likely to believe him because of the prior criminal history on the part of the victim. Another problem is mandated batterer intervention programs. Many states, many jurisdictions require mandatory participation in a batterer intervention program when someone is convicted of specified crimes of domestic violence. And the problem is that these programs, which may be effective and good and helpful for someone who is a batterer, is decidedly unhelpful and may even be harmful to someone who is a victim defendant who has been sentenced for a crime falling within that domestic violence category. These programs focus on addressing power and control issues. However, the problem that a victim defendant faces is not that they need to learn to relinquish power and control, which is what these programs try to achieve with batterers, but rather that they don't have any power and control to begin with. and these programs are not designed to and do not effectively address other issues that victims have. So those programs, by pursuing a criminal conviction, if there's going to be a mandatory participation in better intervention programs, that can be a real problem for victims. Diversion, on the other hand, and we're not suggesting, by the way, that every case involving a victim-defendant should be subject to diversion. There are some cases in which criminal prosecution is the only appropriate solution. However, what we are trying to encourage, or what we would like to do, is to look at diversion as possibly a realistic and effective means of disposing of some of these cases where it's appropriate, where it can be justified. For one thing, with a diversionary disposition, you are going to be avoiding the collateral consequences of conviction that we just talked about, all those unpleasant consequences that just sort of attach themselves to someone who's been convicted of a crime. The economic or employment situation, the disadvantage in the civil proceeding realm. Monitoring, diversionary programs generally have monitoring, which is going to increase the likelihood of offender compliance. The person knows that if they do not comply with the mandated conditions, they are going to be subject to having their criminal charges reinstated. So that's pretty good incentive, and it also, to some degree, is going to diminish the likelihood that the offender is going to be able to use non-participation as a threat. These conditions can provide ongoing support services and problem solving for victim defendants. Such programs as employment or training for employment, substance abuse counseling or treatment, those kinds of services can help the victim defendant achieve the kind of independence that is necessary for them to have alternatives to violence. The history of abuse can also be factored into the sentencing recommendation if criminal prosecution is appropriate. First of all, there is, of course, the option of non-custodial probation with appropriate conditions to address the effects of abuse. And that can have some of the same helpful effect that we just talked about with the diversionary programs. Of course, in this case, the person is still going to have a criminal conviction, but nevertheless, the court can impose conditions of probation, including employment, training, alcohol or substance abuse counseling, anger management if that's appropriate, mental health treatment if that's appropriate. And, of course, even when we're talking about a custodial sentence, the context can still be considered as a mitigating factor in perhaps reducing the length of a custodial sentence, minimizing the amount of time that someone is going to, a victim defendant will have to serve in prison before they can be released on parole, again with appropriate conditions. So we're not really talking about treating battered women differently from anyone else in the criminal justice system because, in fact, this kind of advanced contextualized prosecution is used in other contexts when we have special courts or dispositions available for veterans, for persons suffering from mental health conditions that contributed to antisocial or criminal conduct, community prosecution models, drug treatment court programs. So those are all examples of other contexts, if you'll excuse the expression, in which we use contextualized prosecution to address special issues that result in criminal behavior. And at the same time, these other resources, such as the veterans programs and mental health or alcohol or drug abuse courts, often victims of battering can wind up in those programs too if they come in through a different route. If they aren't charged with a crime of domestic violence against the batterer, they're likely to be caught up for some other offense, which we'll talk about in a moment. But they can wind up in these other programs. And it's important that we coordinate with those other programs as well so that abuse among their clientele is identified, and so that problems such as substance abuse or mental health issues in our clients, or clients isn't the right word, but our victim-defendant population are properly addressed. And it's important to remember that successful outcomes in those programs, such as those for drunk driving, drug possession, and use, often will require that underlying domestic violence be addressed as well. So some of the barriers, the biggest barriers really to contextual analysis outcomes are, first of all, state laws, including sort of a one-size-fits-all response to domestic violence offenders, and communities where we have an unavailability of appropriate treatment programs for victim defendants, looking only at better intervention programs. So we've mostly talked up to now about victim defendants who are charged with violence, especially violence against the abuser, but oftentimes we will find victims of battering who are also charged with other crimes, including drug, gun, or gang-related crime, property crime, child abuse or neglect, and human trafficking. And just as in the case of violence against the abuser, a contextual analysis is effective in examining these cases as well. We can look at the history of abuse, investigate that, where there's a claim of abuse or where there's indications of abuse, and find out whether or how that abuse, that domestic violence, that battering, is relevant to what occurred in the criminal case that we're dealing with. We can consider, as in the case of violence against the abuser, whether there is a defense such as duress, coercion, or necessity, or whether the violence that the victim defendant has experienced otherwise contributed to their conduct. So the history of abuse may be relevant, just as in the setting of violence against the abuser, in charging, in considering whether the abuse might be a complete defense, as in coercion or necessity, whether it impacts the intent of the person, because intent is generally an element of the offense, and sometimes the battering can affect what the person's intent was. It can affect our disposition, diversion versus prosecution, with the same consideration of collateral consequences of both, and also in the sentencing context, conditions of non-custodial sentence and length of custodial sentence, if that is appropriate. In considering whether there is a duress or coercion or necessity defense, and these will most often arise in the context of nonviolent offenses, we can examine the criminal history of both parties, examine the history of domestic violence complaints or orders of protection against the abuser. In the context of gang-related offenses, we can consider intelligence from our gang units, for instance, about gang operations, what kind of power and control there is within the gang, what is their reputation for violence. We can consider statements of the victim defendant as well as that of any credible witnesses, and we can consider overall power and control dynamics in whatever the setting may be. And again, as in the case of violence against the abuser, even where the abuse does not excuse the conduct, it still may have contributed. So we can still consider diversion. We can still be thinking about appropriate services that we can provide in connection with either diversion or probation and mitigation to reduce the length of custodial sentence. So we want to just kind of go over a few of the scenarios or ways in which abuse victims may wind up charged with some of these other crimes. And in the gun, drug, gang kinds of crimes, it's not unusual for females in those settings to be victimized by their intimate partners. Abuse victims may be forced to take part in those activities. Even if they are not members of the gang, they may be forced by a partner who is a member of a gang to allow drug dealing out of their home, for example, to use their home to store drugs, guns, money, or other fruits or instrumentalities, hiding them from the police, putting them in the home of someone without the kind of criminal history that the offender may have, perhaps engaging in other illegal activities. And often abuse victims will also, part of their job will be to claim ownership or take the rap if the abuser is charged with any criminal offenses, particularly possessory offenses, because often the abuser will have a much lengthier criminal history. The victim of abuse may have a much lighter or non-existent criminal history, and therefore their job may be to take responsibility for any drugs, guns, money, or anything else that is found in the home. It's also not unusual for domestic violence offenders to force their intimate partner victims to engage in property crimes, either on their behalf or with their assistance. These can include burglary, theft, shoplifting, receiving stolen property, again, using the home as a storage place for stolen property. Some of the sadder and more difficult situations are when abuse victims are charged with child abuse or neglect. And this can happen in a couple of different ways. Sometimes they're charged with failure to protect a child from abuse by the batterer, or sometimes are even charged with failing to protect the child by allowing the child, and I would put allowing in quotes because often there is no choice, from permitting the child to witness the abuse of one parent by the other. And what's important to remember is that in the context of a violent relationship, victims and the children as well are certainly at much higher risk during the period when the victim is trying to separate from the batterer. So given the history of violence in the relationship, it may be that staying with the abuser is actually the safer course. So it's important to remember that when we're considering whether a victim is being a bad parent, a victim of battering is being a bad parent by failing to protect the child, by leaving the batterer. Another way that this can arise is where there's actual abuse or neglect that has been, in fact, perpetrated by the victim of abuse. And this can arise from a couple of different factors. A common one is drug or alcohol abuse. As we've seen, victims of abuse do not uncommonly turn to drugs or alcohol as a coping mechanism. And, of course, people who are under the influence, who are addicts, either addicted to drugs or alcohol are typically not behaving as good parents. So we can have abuse and neglect that arises more or less directly from these addictions. We also have situations where victim defendants engage in anger or frustration and lash out at the children, basically taking out on the child anger and frustration that they have as a result of being abused themselves. It's also important to remember that claims of child abuse and neglect are not unusual when the abuser is trying to take custody of children away from the victim. And sometimes that is because the abuser actually wants custody of the child, but it's also not unusual for the abuser to simply realize that one of the ways he can most hurt the victim is to threaten her relationship with her children. So it's important when we have a history of domestic violence and a claim by an abuser or a possible abuser that the victim of abuse is committing acts of violence against the children, that we investigate those cases especially carefully, because we certainly do not want to leave the children in a threatening situation if they are in fact at risk of abuse from the victim parent. But by the same token, we certainly don't want to be manipulated by the batterer and pursuing charges that are manufactured as a way of further victimizing the victim of battering. Human trafficking often presents the situation where there is a person who is commonly referred to by the trafficker and people who associate with the trafficker as the bottom bitch. The bottom bitch is basically the trafficker's right-hand woman, his female who, or it could be a male if we are dealing with male victims of trafficking. But a bottom bitch is the right-hand person who assists the batterer and helps to control the other victims. The bottom may assist the pimp or leader of trafficking by either threatening or abusing the other victims. They also may assist the trafficker in recruiting additional victims. It's important to remember, however, that before they became the trafficker's right-hand person, the bottom bitches were often first victimized, not unlike the other victims in the case. And they may be subject to ongoing abuse or victimization even as they are engaging in this conduct to appease or please the trafficker, partially to protect themselves. So when we are considering criminal charges against bottom bitches who victimize other victims in the trafficking scheme, we have to evaluate each one on an individualized basis. It's important to remember that there may be duress or coercion defenses that are applicable, again, depending on what acts the bottom bitch is actually charged with committing or accused of committing. And it's also important to consider whether this person had a history of criminal activity before involvement in the trafficking. In other words, is this someone who is truly a victim, or is it someone who just simply attached herself to the trafficker and immediately began victimizing others? So it may be important to look at that prior criminal history, but often it is important to remember that in most cases, the bottom bitch has been subjected to abuse by the trafficker or by a trafficker before that, before they got into this particular situation. So as in other cases that we've been talking about, diversion is not always going to be appropriate. Sometimes the prosecution is going to be the only option or the only appropriate option. But even where prosecution is appropriate, we can still consider to the victims, the bottom bitch's own victimization in the context of determining whether there should be a cooperation agreement, whether there should be mitigation at sentencing, and as part of determining what appropriate conditions and services should be imposed as a part of the sentence. We also need to consider the possibility, and I've seen this as a prosecutor many times, of simply false reports by an abuser. One of the ways that this can arise is what I would call a preemptive strike. An act of domestic violence has occurred. The batterer has victimized the victim. However, the batterer engages in a preemptive strike by calling 911 first and claiming to be the victim. To corroborate that claim, the abuser may self-inflict injuries, and proper contextual analysis, looking at types of injuries, looking at the history, it is often possible to determine that these claims are in fact false. As we've seen, it's not unusual for abusers to engage in false reports of child abuse or neglect. It's a common tactic when the abuser is seeking to remove the children from the custody of the victim, and it's important to conduct a careful investigation that includes the history of the abusive relationship so that we are neither leaving children in a dangerous situation nor allowing the system to be manipulated by the batterer. We also have cases where a crime or a reported crime is completely fabricated by the abuser. And this can arise in a couple of different ways. One is that it's just another weapon to control or manipulate or harass the victim defendant. It's relatively easy to do. There may be actual evidence manufactured to help support the claim. Or the other way that these fabricated crimes arise is that it can be used as a defense tactic when the abuser is being prosecuted himself for abusing the victim. And this can take the form of fake emails, fake posts on social media, that sort of thing. Those are relatively easy to fake. I've had several cases where I've been presented with printouts of purported emails or purported Facebook posts that turned out to be completely fake, and they were presented to me by the defense attorney, probably in good faith, believing that they were real, and subsequent investigation revealed that they were in fact false. So that's an effort generally to help diminish the victim's credibility on the criminal case, and also to get the prosecutor not to take the case against the actual abuser very seriously. And in these situations, it's important to remember that clearing the victim is not enough. When the falsity of the accusations can be proved, the abuser should be charged. And there are a few different offenses that they can be charged with, depending on the jurisdiction. They can be charged with false reports or falsely implicating another. Usually these offenses, these false reports, at the very least constitute harassment. And often they can be included as part of a stalking charge, part of the course of conduct that an offender is engaging in to target the victim. And so it's important to follow up on that, and not simply dismiss the charges against that he may have charged against the victim, but to actually pursue new criminal charges against him to hold him accountable. So we are coming up to the end of our presentation, but I hope that this presentation has helped to show how important it can be to improve the quality of justice by undertaking contextual analysis. It really does make a difference if you know all the facts about the case, if you're looking beyond the initial police reports and the elements of the offenses. This is an ongoing process. It requires us to engage in repeated ongoing evaluation throughout the course of the criminal investigation and prosecution. We have to continually check our conclusions and our hypotheses and our theories of the case against every fact that's available. And that may mean undertaking ongoing investigation during the course of the case. And our responses, we have to be ready to adjust those responses as we get more information about the individuals and circumstances that gave rise to the criminal act. We have to convey this to the jury. It's not enough for us to simply understand it, but if the case is going to trial, it's important that the jury gets as full and complete a picture of what occurred as possible. It's also important in the sentencing context for the judge to have that information. And that's when we start really doing our job as prosecutors to do justice and not simply to rack up the convictions. Contextual analysis is not driven by gender. If you think about it, really applies to all cases involving a history and context of violence, including heterosexual violence in the domestic violence or dating context. It also applies where we're talking about same-gender violence in the LGBT context. It also applies when we're talking about veterans who are using violence, where the violence may be impacted by post-traumatic stress disorder. It also applies in the context of family violence, where we're talking about violence between siblings or from parent against child. And if you return to the original Sarah fact pattern and recall that and reapply this analysis, replacing the individuals with different backgrounds, genders, or sexual orientations, the analysis really does not change. By doing this contextual analysis in every case, we can enhance victim safety. We can make sure that victims are not being re-victimized as a result of police response and prosecution response to these acts that they are charged with. We can help to ensure that abusers are held accountable for their actions fully and appropriately. Where victim defendants are criminally responsible, we can help make sure that our responses there are proportionate and just. We can make our communities safer by continually keeping these principles in mind as we go forward and investigate and prosecute domestic violence cases. Thank you. Charlie, if you want to talk about some of our resources.
Thank you, Terry. Yes, this is Intimate Partner Violence Victims Charged with Crimes, the previously published monograph that's available on our website. You can also find this and additional resources on our library page with monographs, prosecutors' resource, strategies, newsletters, strategies in brief, statutory compilations, and case file summaries, and additional resources. I want to thank Terry and all of you who viewed this webinar for your participation and dedication to increasing victim safety and offender accountability in your communities and across the country. When you exit iLink, we encourage you to visit our website, www.equitasresource.org, to register for future webinars and training events and to review additional information about EQUITAS. Please remember that EQUITAS is a 24/7 technical assistance provider available to respond to questions, concerns, and training needs as they relate to the prosecution of violence against women. So on behalf of EQUITAS, thank you so much for viewing today's